Okay, let's unpack this. Imagine you're advising someone, maybe a client in a tutorial scenario, who feels they've made a really bad deal.
Right.
And it's because they trusted someone close, could be family, could be someone managing their affair.
Yeah, someone in a position of influence.
Exactly. And the deal looks incredibly one-sided, totally unfair. They regret it, and you're looking at the facts thinking, hmm, something's not right here.
That gut feeling that maybe it wasn't just a simple bad bargain.
Precisely. And that feeling, that's what we're digging into today, specifically for you analyzing these kinds of legal problems. We're tackling a really key concept in contract law, undue influence.
A really important one.
Our mission here is to equip you with principles using the source guide you've provided to really analyze these scenarios effectively.
So you can spot undue influence, understand the legal consequences, especially when you face it in, say, a problem question or a case study.
Exactly. Getting you ready for that analysis.
Right, because trust, well, it's vital, isn't it? Especially when one person relies heavily on another. But as you said, that influence, it can be misused.
So where does the law draw that line? How does it distinguish proper influence from, well, undue influence?
That's the core question. And this deep dive will walk through the main ideas, use that practical example from your materials, and link it to some key legal cases.
All aimed at helping you navigate these tricky situations confidently.
And this whole concept, undue influence, it sits under a bigger heading in contract law, doesn't it?
Ah, yes. You mean vitiating factors.
That's the term, yeah. It's in the source materials.
Yeah.
What exactly does vitiate mean in this context for a contract?
Good question. Basically, if something vitiates a contract, it impairs its validity, it weakens it, makes it potentially void, or more often voidable.
So it spoils the agreement, in a way.
Yeah, you could say that. Destroys its legal force, potentially.
Hmm.
Things like, misrepresentation, mistake, duress. And our topic today, undue influence.
They all attack the foundation of the agreement.
Right. They can allow a party to sort of escape the contract.
Got it. Contract killers or maybe contract wounders.
Huh. Something like that. And undue influence, our focus, it's about one party, the dominant one, using their influence over the other to get some kind of unfair advantage.
That's the heart of it. And it's what we call an equitable doctrine.
Meaning the court looks beyond just the strict words on the page, more towards fairness.
Exactly. Equity aims for fairness. And if undue influence is found, the main remedy is that the contract can be set aside.
Set aside, like canceled, hit the undo button.
Pretty much. The proper legal term is rescinded.
Okay, rescinded.
And rescission means the court tries to put both parties back in the position they were in before the contract was even made, as if it never happened.
Right. Now, the source material mentions there are two main types, or two ways to establish it. Actual undue influence and presumed undue influence.
Correct. Actual is where you have to actively prove the specific acts of pressure or influence.
You need concrete evidence of the arm twisting, so to speak.
Yeah. But for today, and often when you're analyzing problem scenarios, the real focus, and what's highlighted in the guide you've got, is presumed undue influence.
That's where the interesting analytical steps often happen, right?
Definitely. Because with presumed undue influence, you don't necessarily need to prove specific acts of pressure. It arises automatically from certain types of relationships.
Relationships built on trust and confidence.
Exactly. If you have one of those relationships and the transaction itself looks questionable, the law actually presumes that undue influence occurred.
Okay, that's a big deal. The law just assumes it.
It assumes it, yes. And here's the crucial part for your analysis. The burden of proof flips completely.
Flips. How so?
Well, normally, the person claiming something has to prove it. But here, once the presumption arises, it's not up to the weaker party to prove they were influenced.
Okay.
It's suddenly up to the dominant party, the one with the influence, to prove that no undue influence happened. They have to show the other person acted freely, independently, with full understanding.
Wow. So the person who benefited from the dodgy-looking deal has to prove their innocence, essentially.
That's a good way to put it, yeah. They have to rebut the presumption. And as you can imagine, if the relationship is clear and the deal looks really unfair, that can be very, very hard to do.
Makes sense. What's the principle behind that flip?
The underlying idea mentioned in the materials is basically fairness. The law says if someone puts their trust in you and you abuse the influence that comes with that trust to get an advantage, you shouldn't be allowed to keep that advantage.
Right, it prevents exploitation of trust. So what relationships trigger this presumption? Are there specific categories?
There are some well-established ones, yeah. historically recognized categories where trust and influence are seen as inherent. Your materials list some classics: parent and child,
Okay.
guardian and ward, doctor and patient, solicitor and client. In these, the presumption is often quite strong.
But it's not only those, is it? What if it's, say, an elderly person relying on a neighbor, or like in the case study, a nephew?
Absolutely crucial point. No, it's not a closed list.
Yeah.
That's key for analyzing problem questions.
Right.
Your materials make it clear. You can establish a relationship of trust and confidence based on the specific facts of the case, even if it doesn't fit neatly into one of those traditional boxes.
So you look at the actual dynamic.
Yeah,
Did one person genuinely place trust and confidence in the other, and did the other accept that position of influence?
precisely. It's about the reality of the relationship.
Okay, that makes sense. Definitions are one thing, but applying it, that's the skill, especially for law students tackling scenarios. Your source guide includes a case study. The antique desk case study. Looks perfect for this.
It really is. It's
Yeah.
got all the classic ingredients you need to look for. You've got Mrs. Eleanor Vance. She's 85. Her health isn't great.
And she's heavily reliant on her nephew David for basically everything.
Yeah, not just a bit of help. The facts say he manages her finances, pays her bills, deals with investments, and provides daily care.
And crucially, it says she trusts him implicitly. Total dependence, explicit trust. That's a strong start for establishing that relationship of confidence we talked about.
Definitely lays the groundwork. Now,
Yeah.
Mrs. Vance owns a valuable antique desk. Estimated value, $50,000. David apparently likes it.
Okay, and here's where it gets dodgy. David, who manages her money and knows she has plenty of savings,
Uh-huh. He sees the bank statements.
he tells her she urgently needs cash for some unexpected but actually minimal medical costs, creates a false panic.
Deceptive from the start. Then what?
Then, conveniently, he suggests she should sell the valuable desk to raise this needed cash.
The desk he admires.
And immediately, he offers to buy it himself. Wait for it, $5,000.
$5,000 for a $50,000 desk? That's wow.
Right, and he adds pressure, saying finding another buyer would be tough, framing it like he's doing her a favor.
Playing in her reliance and trust.
Totally. So Mrs. Vance, trusting his financial advice completely, relying on him, she agrees, sells him the desk for $5,000. Done deal. Until another relative visits later, finds out what happened, checks things out, and confirms the desk's real value and that Mrs. Vance had plenty of money all along.
So the truth comes out.
Yeah.
And Mrs. Vance feels completely taken advantage of and wants to undo the sale.
Exactly. So let's put on our legal analysis hats. How do we break this down using the presumed undue influence framework? First step, the relationship.
Okay. Does the relationship between Mrs. Vance and David show that necessary trust and confidence for the presumption to kick in?
I'd say absolutely. It's not parent-child, sure, but the facts just scream reliance, don't they? Her age, health, his total control over finances and daily life, her explicit trust.
It seems to go way beyond a standard aunt-nephew dynamic. Looks like she placed enormous trust in him, and he clearly accepted that role. Fits the bill for a relationship of trust and confidence on the facts.
Okay, step 1, relationship established. Step 2, did David abuse that trust?
Well, let's look at his actions. He knew she didn't need the money, that's key. He manufactured a crisis.
Lied about her finances.
He initiated the sale of a specific, valuable asset, positioned himself as the only buyer, offered a price that was, frankly, ludicrously low,
10% of its value.
and used his position of trust, her reliance on his advice, to push the sale through. It strongly suggests an abuse of that trust.
Definitely looks like it. Which brings us to the transaction itself. Your materials mention the transaction needs to be manifestly disadvantageous, or at least call for explanation.
Right, selling a $50,000 desk for $5,000. I think that qualifies.
You think. It's not just a bit disadvantageous. It's a massive loss for her.
Yeah.
It just shouts that something's wrong, that this wasn't likely a free-informed decision.
Absolutely. It clearly calls for an explanation, and the obvious explanation points towards undue influence.
Now, this whole scenario, it rings a bell. It sounds quite similar to a classic case, doesn't it? Tate v. Williamson.
Yes, a cornerstone case in this area, and definitely relevant here. Your materials probably highlight it for good reason.
Remind us of the key facts there.
Sure. In Tate, you had a young man, Tate, who was in debt. He went for advice to Williamson, who was a relative he trusted.
Okay, similar setup relative, trust, seeking advice.
Williamson then offered to buy Tate's property for £7,000. But Williamson knew it was worth considerably more, maybe double that, and he didn't tell Tate.
So he withheld crucial information about the value.
Exactly. Tate agreed, sold the property, and later sued to have the sale set aside.
And what did the court say?
The court found Williamson was in what they called a fiduciary relationship, basically, a relationship of trust with Tate. Because of that trust, Williamson had a duty to act in Tate's best interests.
Which included telling him the real value.
Precisely. By withholding that information and buying the property cheap, he breached that duty. The court presumed undue influence and set aside the sale.
Okay, so comparing Tate to our antique desk case study, the parallels seem pretty strong.
They really do. You've got the relationship of trust relatives, one vulnerable or seeking advice. Tate in debt, Mrs. Vance elderly and reliant.
Both involve selling property land in Tate, the desk here.
And critically, both involve the dominant party buying it at a significant undervalue while keeping quiet about crucial facts.
Williamson hiding the land's value, David hiding Mrs. Vance's savings and the desk's real worth.
Yeah. The decision in Tate v. Williamson gives really strong backing to Mrs. Vance's potential claim. It shows how courts approach these situations where trust is exploited in a bad transaction.
So let's tie it together for the case study analysis. We've established the relationship of trust and confidence. We've seen the transaction is clearly disadvantageous and calls for explanation.
Yes.
So under the doctrine of presumed undue influence, the law presumes undue influence occurred.
Correct, which means the burden shifts.
Right. It lands squarely on David. He now has to prove that Mrs. Vance's decision to sell him that $50,000 desk for $5,000 was, quote, her free, independent, and informed act.
And given his actions, the lying about her finances, initiating the sale, the lowball offer, the pressure.
It seems almost impossible for him to prove that, doesn't it? His actions seem to actively demonstrate the undue influence, rather than rebut it.
It certainly looks that way on these facts. He'd have a very steep hill to climb to convince a court otherwise.
So, assuming Mrs. Vance brings a claim and succeeds, what's the result? What's the remedy?
Well, as we touched on earlier, the contract is voidable at her option.
Meaning she gets to choose.
Yes, she can choose to rescind the contract.
Rescind, put things back to how they were.
Exactly. If she rescinds, the court would typically order the desk to be returned to her, and she would have to return the $5,000 to David. The goal is restoration to the pre-contract position.
Undoing the transaction caused by the undue influence.
Precisely.
Okay. So, for anyone listening, particularly law students tackling problem questions on this, the analytical path seems clear from your materials.
Yeah, you first identify the relationship. Is there that element of trust and confidence, either in a recognized category or on the specific facts?
Then, look hard at the transaction itself. Is it fair? Or is it disadvantageous? Does it raise red flags? Does it call for explanation?
If the answer to those is yes, then bingo, the presumption of undue influence likely arises.
And then the burden flips, and you need to consider whether the dominant party could possibly rebut that presumption based on their actions.
Don't forget to bring in relevant case law, like Tate v. Williamson, to support your arguments by drawing parallels.
It really highlights how contract law isn't just about holding people to their bargains, is it? It's also about protecting people, especially vulnerable people, from exploitation.
Absolutely. It's a crucial balancing act within the law, protecting freedom of contract, but also ensuring fairness where trust is involved.
It makes you think about how subtle influence can be sometimes. It's not always overt pressure.
No, often it's much quieter. Leveraging dependence, withholding information, a gentle nudge in the right direction. That can be just as powerful, if not more so.
Recognizing that subtlety and then applying the legal framework like we've discussed, that's the key to moving from just feeling something's unfair to building a solid legal argument.
That's the skill you need to develop.
It certainly is a fascinating area.